All right, good morning, everyone. Welcome to the Wednesday morning docket of the Kansas Court of Appeals. I'm Judge Anthony Powell, and I'll be the presiding judge for this morning's argument. With me are two very distinguished judges that I'm pleased to have on the panel. One is Judge David Bruns, and the other is Judge Steve Lieben, who's recently retired from our court. We're very happy to have him back with us for this docket this month. We have one remaining case on the docket this morning. That case is in the matter of the equalization appeals of Wal-Mart stores et al. Case number 122162. And could the court have the appearances, please? And I'll start with the appellant.
The Board of Commissioners of Johnson County, Kansas appear by and through Ryan Carpenter, Assistant County Counselor, Your Honor.
And good morning. I'm Linda Terrell with the Property Tax Law Group, and I represent the Eppley, Wal-Mart, and others.
Very good. Thank you very much. Counsel, we appreciate you being here, having some patience with our technical issues this morning. This case is set for 15 minutes aside. We have read your briefs and are familiar with the arguments in the case. Mr. Carpenter, do you wish to reserve any time for rebuttal?
Your Honor, the county would respectfully reserve 3 minutes at the end for any necessary and proper rebuttal.
Very well. So you have 12 minutes.
Members of the panel, judges, thank you for the time today. The county is here respectfully arguing that the Preeb decision upon which the BOTA based its decision in this matter, that the foundation underlying that case has shifted, and that it's time for this court to re-examine what Preeb stood for and whether it's still good case law today. In fact, another panel of this court in an opinion issued on April 2nd, 2021, stated that, so although there may be some good fodder at some point for re-examining Preeb, the county's arguments are undeveloped and provide no basis for us to do so here. It's fortuitous that we would appear before you today with a more developed argument about why Preeb should be re-examined. There's a trend in other jurisdictions that, with case law cited to in Preeb, that they are changing their opinion of the value of build-to-suit leases and whether that can be equal to market rent. As set forth in the brief, the state of Wisconsin has overturned the case cited in Preeb, which is Walgreens versus City of Madison, and Great Lakes Quick Lube LP versus City of Milwaukee. In that case, the Court of Appeals of the state of Wisconsin determined that a sale of a prior sales leaseback arrangement was indicative of market rents and therefore is an accurate sale and should be used to value the property.
Let's say, counsel, let's say that you're right, that can be an accurate way. Is that the only way? And are you asking us to find that there's only one way to value, I'm going to call them a box store property?
Sure. That is not the only way, Judge Bruns. In the appraisal field, the contract rent can be equal to the market rent, it can be greater than the market rent, or it can be less than the market rent. For example, all learned treatises governing appraisal, either mass appraisal or single fee appraisal, require the property to be valued using market rents at stabilized occupancy. None of the learned treatises governing the valuation of real estate require the real estate to be valued as if dark or as if vacant. So
you would realize or would agree with me that there's a controversy in this. I'm looking at, I think you actually provided it to us, the Commercial Big Box Retail Guide to Market-Based Valuation, and it starts with the premise that the theories about how to value them have resulted in great debate, recurring controversy. It seems to me that perhaps the Board of Tax Appeals is who needs to hear these types of cases, hear the conflicting theories, and then make a decision.
And absolutely, Your Honor, it is an area of dispute. And as set forth in the county's brief, the Lenhoff position paper, which the pre-case cited to, was also very controversial. And these arguments were put before BOTA, as you'll see in the record on appeal, that the county's trial brief of why PREB is wrong is incorporated within the record, Judge. BOTA in this matter acknowledged that the county appeared to be preserving its record for appeal to discuss this issue. And the BOTA, feeling that it had no option but to rely on PREB, relied on it, knowing that the county, or not knowing, but understanding the county would raise these as an issue. And
Can I see if I can simplify? I'll come back to you when my phone's not ringing.
So I'll ask you a preliminary question here. Remind me, it was it was in the early 2000s, if I remember right, or about 2011. What year was PREB decided?
2012, Your Honor.
Okay, 2012.
And I believe they were 2006 and 2007 valuations that were heard before what was then known as CODA, Your Honor.
Right. I remember those days. We basically have a decision that's about a decade old. And in that time, this court has not backed away from PREB, even though there's some questions in that opinion. The Kansas Supreme Court has not done anything to say that PREB was wrong. And perhaps most importantly of all, some of these public policy issues that could have easily been resolved if they disagreed by the Kansas legislature, there's been no action taken. If anything, perhaps they've doubled down on the definitions for valuation. You know, haven't people relied on this? Haven't taxpayers relied on this? Even governmental entities, attorneys, judges, Board of Tax Appeals relied on this. And is it proper for us to pull the rug out from under them at this point?
Well, to answer your question, Your Honor, this matter, this interpretation of PREB has not made it to the Supreme Court yet. In fact, this might be the situation where it does for ultimate.
And it might be, but they haven't. I mean, they could have reviewed. There have been a lot of cases that have come up they could have reviewed, but they have not reviewed any of these cases that I know of.
And this is the first time that it has, to my knowledge, Your Honor, to respond to that question, that it has been briefed to this extent. Moreover, stare decisis is presumed, but I would cite to State versus Clark that unless this court is clearly convinced of a rule of law established in its earlier cases was originally erroneous or is no longer sound because of changing conditions, and that more good than harm will come by departing from the precedent, the county would respectfully argue that in this case that PREB is no longer good law because the out-of-state cases upon which it was built have overturned the decisions upon which it was built. Therefore, the foundation is shifted. As cited too in the county's brief, both New York and Wisconsin, the cases that the original PREB court cited to, have changed their positions with regard to this. And
is that a public policy issue? I mean, it seems to me like we may be on the wrong side of 10th Street here.
You know, it could be addressed via public policy, but the courts are not without power to address it if it's no longer good law.
Counsel, let me ask you, I want to see if I can simplify this and get to the question I was going to ask before my phone took over my home hearing room. So the shorthand version that I think the parties and the Court of Tax Appeals have used is that the taxpayers want to appraise this as if vacant and available for lease, and you want to appraise it based on market rent as shown in the actual lease. I'm simplifying things, but we've got appraisers that would agree both of those theories are plausible ways of getting to value.
And in response to that, Your Honor, the county would respond that only one of these properties is leased. So what the county has done in these matters is they have followed generally accepted appraisal principles and have applied market rents at stabilized occupancy to determine the value. For example, the only one of these properties that's before this court today that is leased is the Wal-Mart in Roland Park, the one that is referenced by TMM, and that property actually has a contract rate of $8.50 per square foot. The county has retained expert appraiser in that matter. For market rent, use $7.50 per square foot. These types of properties, and it should be in the record, it was offered in testimony, I believe, by Bernie Shaner, about 85 to 86% of these properties are owner occupied. So you usually don't have leases. So what you do is you go to the market, you look at the most comparable and highest and best use and apply those to determine what would be a market rent. So only one of these is leased, and the county's retained expert did not use contract rent in that case.
Okay. And then the basic argument I think you're making related to the Preeb case is that Preeb has unduly limited the appraisal testimony that the Court of Tax Appeals is able to consider to get to market rate rent and therefore value of the property.
And that is a fair summation of where we're at. Moreover, the county would respectfully argue that the single defining factor in Preeb is that contract rent should not be used to value them. And it's a fairly basic proposition, but the appraisal treatises that govern the appraisal of property indicate that contract rent can sometimes be equal to, greater than, or less than market rent. So what the county is doing and what its retained experts did is went to the market to determine what would be most indicative of market rent in this matter, following the idea that there's no requirement anywhere in any learned treatise or appraisal governing body that requires you to value these properties as dark unless they are actually dark. And if they're actually dark, then there would be a lease up for it, but you would still be trying to figure out what the market rent at stabilized occupancy would. The county repeatedly goes to the market rent, market expenses, market vacancy and collection, market capitalization rate, go to the market as all generally accepted appraisal practice dictates. The county would respectfully argue as well that BOTA has perhaps impermissibly expanded the decision in Preeb to read words into it that aren't necessarily in it. And all the county is asking is that we value these through generally accepted appraisal standards, that you look at what the market rent is, that there's no requirement that it be dark. And circling back, not necessarily to your question, Judge Liebent, but to Judge Brunn's question, no statute in the state of Kansas has defined what fee simple is in the appraisal of real estate. The court seemed to have attached onto the definition of fee simple that is found within the appraisal world. And absent a statutorily defined definition of fee simple, then the county believes that the legal definition, which is peculiar and more stringent, applies, and that we are to value the fee simple. And a property can be held in fee simple, but also have a lease. As members of the court know, there's no such thing as lease fee taught in any property law class in any law school, unless it's changed in the 24 years since I had property. Lawyers doing math. I apologize, Your Honor. It looked like you had a question.
You're bringing back some bad memories about bundles of sticks. But in any event, there does seem to be a controversy even on what fee simple means in the appraisal world. And then we have a legal definition that could be different yet. So how are you saying that we should resolve that, or why should we resolve that? Shouldn't we just let the experts come in and render their opinions based on what they understand fee simple means?
Well, the county would respectfully argue again, Judge Bruns, that absent a definition, then the courts are left with no a specific definition that applies to real estate. Then the courts are left with the definition that's legal in nature. And in that case, fee simple means the whole, and I apologize because my memory is a little bit, all the bundles of sticks. That includes your right to lease out the property.
Well, I went to Washburn. Professor Merle Duncan only had one big bundle, but I think that signifies that even within the definition goes all over the place. But let's talk about this specific case.
Before we get out of the definition, though,
okay.
I want to understand what the county's position is. Syllabus paragraph 5 in PREB gave us a definition of fee simple, and it threw in this concept of least fee interest. And I want to know if you're saying the definition of fee simple in PREB is inaccurate as a matter of law, and if so, what definition are you arguing we should adopt?
The county is respectfully arguing that we should adopt the definition set forth in Black's Law Dictionary, Your Honor. Fee simple in the appraisal world means slightly different. It talks about discounting for encumbrances, but as we know, encumbrances can benefit the property. They can detract from the value of the property. And the county believes there is no requirement that fee simple indicates that these properties are dark or that they are not leased at market rent or that they're required to be valued using second generation rents or rents from properties that are in line and not the same highest and best use as the property being appraised.
What do you claim is inaccurate in the paragraph 5 definition of fee simple from PREB?
I believe that definition of fee simple requires the courts to look at the lease in place first, the actual definition, the actual legal definition set forth in Black's Law Dictionary, Your Honor.
So you're saying, and when we define fee simple, we simply should not be discussing lease interests at all?
No, because and to circle back to Judge Bruns's comment, there is no such thing that I can recall. Again, memories fade. I haven't owned property for 24 years, but I certainly do not recall being taught anything about leased fee in law school. I don't know if you teach property while you're teaching, Judge Lieben, but I don't believe that's changed because we know the common law is slow to change.
None of my criminal law and evidence that I've been teaching this year is going to come into play in this case.
Fair enough.
Let me circle back to something you commented on earlier, because it gets us in now to the kind of the meat of this case, and you're running out of time already. You mentioned Mr. Shaner. Mr. Shaner prepared, or at least partly was responsible for what is referred to in the briefs as the Valbridge report. Is that correct?
Yes, Your Honor.
And we're dealing with the 2016, 2017 tax years here, correct?
Yes, Your Honor.
So I take it, since his report's dated January 30th, 2017, that it was not used by the county to reach these valuations. Is that a fair statement?
I believe, Your Honor, that was used for 2017. You are to value properties as of 1/1 of the effective year date. Technically, you can use studies afterwards to do that because annual notification of property values doesn't go out until March. So I believe.
Is that new math? So you decide an answer, then after the fact, you come up with the evidence to support that answer? They didn't teach that back when I was in elementary school.
I would suggest that, much like a retrospective appraisal, of which all the experts use, you can use data. I mean, the final report is dated January 30th. I believe a preliminary, for lack of a better term, working copy of that, I believe, Your Honor, was available to the appraiser when making.
When was the 2016 valuation reached by the county appraiser?
It certainly would not have been used for 2016.
Right. But when was
It-
it do you know when the valuation was determined by the county appraiser for 2016?
The notifications would have gone out in March of 2016, Your Honor. I don't
But
know.
I assume they valued this property quite a bit prior to that.
Correct. I believe all gets wrapped up in about January, I believe. We're talking about 5 years ago. And to be quite frank, I was not an employee of the county at that time. So
Okay, so in
Let's-
2017, you could probably give me the same answer. You don't know when the county appraiser actually came up with this value.
I think it's a long process, and I think the qualitative and quantitative analysis to make sure they're good values generally goes on in January, and then the values are pushed out in March, Your Honor.
The reason why I asked that is I do wonder if this is a good case to be addressing PREB. Seems like subsequent years after Mr. Shaner has rendered his report and the commercial, did you provide me with, or me, the court, did you provide the court with the commercial big box retail guide to market value, based value? Did you provide that?
That should be in the record. I can't cite to the record.
Well, no, but you provided it, correct?
Yes.
That's what I thought.
The county
And it's
did,
not
yes.
dated until September 2017, which is well, no matter which date we use, well after the valuations that we're talking about in this case. Is that correct?
That is correct, but it is.
So what relevance do they have other than just to serve as ammunition for your expert witnesses in this particular case? Now, going forward, perhaps it would be different.
Well, all that you would find in the record, Your Honor, that all witnesses that testified cited the IAAO as an authoritative source in the appraisal world. It is more prevalent in mass appraisal than others, but that's a publication to show that this was given much thought.
And I don't doubt that, but they didn't have a crystal ball to know what was going to be published in September 2017. The county appraiser wouldn't have, back when, I don't know if it's a male or female, he or she valued this property. I
don't know how long it took IAAO to publish that. I will say that the county.
Well, it's dated September 2017 on its face, which would have been well after the valuations in this case.
And I understand that, but with all due respect, Your Honor, sometimes these papers take a while to come forward. I will say.
I understand that.
You will see that one of the authors of that paper is Paul Welcome, who was the Johnson County appraiser at that time, and therefore he was cognizant of the issues, at least.
No doubt, and may wanted to justify his own appraisal, perhaps. I don't know. I'm not saying that he did or didn't, and I'm not objecting to having it in the record. I'm just trying to clarify that it was not relied upon in reaching the valuations in this case.
That is correct,
okay.
Your Honor.
And even in September 2017, it was still recognized by IAAO that the theories about value were under great debate, and that it was continuing as a reoccurring controversy.
Correct, and that would go back to the point where the states that New York, I would point to New York and Wisconsin, that subsequently overturned cases upon which PREB relied, showing that the foundation is shifting. It's a battle, not battle, that's not a good word. It is an issue of party debate in many states in the union, Your Honor. Yes, it is. The county would absolutely agree with that. And even though that article is dated September of 2017, it also goes to show the thought process of the Johnson County appraiser, who ultimately signs off on all the valuations of the property in the county, and may give input to his mindset of why the county went to the market, why the county valued it the way they did. So it may be beneficial from that regard, certainly, Your Honor.
Okay. And now let's assume that we do not overturn PREB, that PREB is still good law. Isn't the county just asking us to reweigh the evidence presented to the Board of Tax Appeals? I mean, basically, your primary argument is a legal argument.
Yeah, the county is asking you to re-examine the legal conclusion of the Board of Tax Appeals and asking you to re-examine whether PREB is still good law, because the foundation has shifted the tide is changing on that. So we're not asking you to reweigh the evidence per se. We're asking you to determine whether the legal conclusions reached by the Board of Tax Appeals is still based on good case law.
Council, thank you for your time.
Am I out already?
Yeah, gone way over, but given the
I
importance,
apologize.
that's not your fault.
We did pepper you with a few questions.
We helped.
Used up a lot of time, so that's fine. This is an important case. So, Ms. Carroll, I'm going to give you, let's just call it a generous 20 minutes.
Thank you. I actually had a pre-planned, wonderful oral argument ready to go, but maybe if I just give my introduction and then address some of the questions, maybe I can clear up some of the confusion that's happened so far. Our argument is very simple. The order of the Board of Tax Appeals should be sustained because it correctly applied existing law and it was supported by substantial and competent evidence. And further, no grounds for reversal as the county's knowing and willful failure to follow the law should never be grounds for a finding for the appellant. Stated another way, the order of BOTA should be affirmed as the appellant has failed to demonstrate it carried its burden of proof, failed to identify where any issue was raised or ruled upon, failed to identify substantial and competent evidence supporting overturning BOTA, and failed to demonstrate how any argument raised by appellant diminishes the findings of the Board of Tax Appeals. Now, let me just do a couple of things. First of all, the argument that this is hotly contested is overstated. Mr. Carpenter referred to the article by Mr. David Lenhoff, one of the most respected appraisers in the country, as being hotly contested, but he didn't neglect, he neglected to mention that the article is cited by the book, The Appraisal of Real Estate, which is the authoritative text for appraising real estate, and that the article won the Appraisal Institute Swango Award for Article of the Year. So it is not wishful thinking that it is wishful thinking to think that it is hotly contested. The second point I want to make is this question.
Counsel, can I,
Yes.
on the contested question, this is not the first case to get to the Court of Appeals involving massive differences between a county and taxpayers over the appraisal of similar big box storefronts.
Yes, mostly mine.
And wouldn't you say that's fairly significantly debated? There were experts in all the cases that had completely different opinions. In this case, there certainly is strong support on each side for their expert opinions. I don't know how you can say this isn't a highly contested issue, even as to the methodology that ought to be followed.
It is certainly Johnson County takes an aggressive position, but I included the Menard case, for instance, and that was like 120 some pages that agrees exactly with Preeb. And actually the Judge Bruns, the IAAO paper was raised in that, and the issue of changing the definition of fee simple to mean something other than the definition in the appraisal of real estate was discussed in Menard. And Mr. Corpax, who testified in our case, testified under oath in the Menard case that that article carries no more weight than an opinion as to the definition of fee simple by his mother's knitting club. And let me just say one other thing about that, if I could.
Well, if his mother's knitting club is made up of appraisers, perhaps.
I don't think it is.
Oh, okay.
But let me just say one other thing too, and I noted this in my brief. The Appraisal Institute is the highest preeminent appraisal organization in the country. And the Appraisal Institute has written a letter to the IAAO about that paper and is calling, well, they have two papers, calling them factually inaccurate, conceptually flawed, and misleading. So it is just a paper. And if you read it, there are no citations to anything. It's not supported. It's just kind of, I refer to it as the musings of the authors, who, by the way, most of which had a role in this case. Not only was Mr. Welcome on that committee, but so was Mr. Corpax and so was Dr. Hamilton. Yes.
Since you're on a by the way topic, I want to go back to more central issues,
Yes.
which is the basic question here, I think, relates to whether you're valuing these properties as vacant, right?
It's, as Judge Schroeder said in I think it was the Target case, we're not valuing a vacant building. We're valuing a property on the assumption the owner occupant will vacate upon the sale, which
And
is
it's-
how we sell our houses. We don't call them vacant or dark when you sell your house.
Right, but you're assuming that it's vacant and available for lease for purposes of valuation.
Well, yes, that is the Appraisal Institute position. They define it as saying it is available to be leased. not already.
It's also your position in these cases, right?
Well, yeah, the Appraisal Institute and I are on the same page. The
Okay.
definition says available to be leased, not already leased.
And my next question is it your argument, was it your argument before the Court of Tax Appeals that PREB precluded using the appraisal methodology that the county's experts used?
It's not necessarily the methodology. They use an income approach. That's perfectly fine. The question is, what is market rent? And what PREB stood for is this, that build-to-suit transactions have rents that are not derived from the market. So when Mr. Carpenter said, we use market rents, no, they do not. Build-to-suit rents have nothing to do with the market rent. Let me just give you an example. If let's assume Walmart was going to do one of these build-to-suits, they would be contacted by a developer and they would agree that they're going to locate a store there. They would give them preliminary plans. They don't even know where the land is yet. And then they would say what prototype they wanted to build. And then the guy comes back and says, here's what it's going to cost. There's already a store there. We need to buy that guy out of the business. We need to tear down the building. We need to make some environmental changes to the land. And then we're going to build your property. And we might even give you, if Walmart says we'd like $1 million in cash to go do the next transaction, they do that too. These things that are all unique get lumped in, and it's nothing like a sign outside that says for rent. It is like trying to say, I'm going to be able to value my house if you just look at my mortgage. It has nothing to do with market rent. So that's the issue. It's not the issue of whether it's vacant. That's Target and ARC Sweet Life.
Here's the problem I've got with your side of the case position related to PREB. And so I want to be sure I understand what your position is on this. Your position is it has nothing to do with what the value of the property is or the actual market rate for rent could be. My thought would be it may not be a one-to-one indicator, but it's really in the realm of something an expert should and could consider. But PREB has taken that off the table and said, as a matter of law, we won't let experts rely upon the market rate of a build-to-suit lease.
Right. Well, of course,
And so I'm wondering whether the correct rule, both in PREB and today, should have been we define what a fee simple is, and we leave it to the Court of Tax Appeals over time to keep listening to experts as they have an evolving discussion of how this works out in the market. Because the way it works out in the market in 1982, the way it works out in 1991, 2012, 2021 is not necessarily the same. And it does seem to be a highly debated expert opinion issue.
okay, Judge Lehman, I hate to disagree with you, but
That's why I'm inviting you to come. I want to know your position on that.
The PREB decision says you can't use them because they're not market derived. So they're over here in an investor market, not in the real estate market.
But in this case,
it's-
we've got experts who are saying they are market derived, but we have decided as a matter of law, they can't be.
Okay,
And I'm trying to
What-
figure out
it
how
is-
we, the Kansas Court of Appeals, got this knowledge that made us experts in the appraisal area so that we can rule out a whole category of evidence that appraisers in the field seem to be feeling they can rely upon.
okay. So I'm going to address all of those things. First of all, the PREB decision is not as narrow as you just described it. It says you can't rely on these unless you can disentangle them. Now, here's the problem that the county has and the county's expert witnesses, which both have found all of their appraisals were not prepared and developed and written in compliance with the law. They ruled them all out.
In compliance with PREB specifically.
Well, or Target or ARC Sweet Life or Kansas Star. I mean, it's a lot of them. They have a lot.
But
But
those
they
are all
focus-
unpublished decisions. Preeb is the one that controls here.
Target is published. So Preeb
Okay.
and Target are the two they cited.
All
Now,
right.
they don't disentangle. And in fact, Shaner's own testimony was he saw no need to disentangle. So that's the dilemma. If the taxpayer or if the county had brought in some actual market leases where parties are negotiating the rent to occupy a building, and then had said, I've got to build a suit in here as well, but I have talked to the owner of the property, and I have looked at the lease, and I have determined that it's comparable to market. You can't, but the problem that the county has is that their witnesses, none of them did that. They just say, I think it's the same. And if I could clear up one other thing, I want to clear up two things about this. First of all, you don't have to get past page 6 of the appraisal of real estate before the preeminent authoritative text says, if there are leases in place, even at market rates and terms, the interest is correctly identified as a leased fee. So we are to value the fee simple unencumbered. And I would disagree. Walgreens has not been overturned. So let's just talk for a moment about the arguments with free. Walgreens is still good law in Wisconsin. The case that the county cites that says that a sale leaseback is good evidence of what the property would lease for, that decision, I think, is the Quick Lube case. It actually hinged on a determination that it was not a sale leaseback. I want to talk about the Grant County Assessor versus Carasotes case. That's an Indiana case, and they're not a fee simple state. All of the Ohio cases have been overturned by statute. Ohio is clearly now a fee simple unencumbered. The New York cases are still the whatever they call them, the pharmacy wars are still going on. And one other thing, the appellant writes in the brief that Preeb is correct that a lease does not increase the value of the fee simple, which is fundamental. There's no lease in a fee simple, so a lease can't increase the value of a fee simple. But he argues that occupancy quality of the tenant in the term of the lease may, and he cited to page 407 of the appraisal of real estate. The problem is that citation is very misleading because it's in the section of the appraisal of real estate that discusses how to value a leased fee, not a fee simple. And in fact, directs you that leased fee sales are not recommended when the interest to be valued is the fee simple. So, and dark is just a word made to make fee simple look more ominous than it is. Nobody has argued that the building is vacant, abandoned, nothing. It's that it is occupied and it will see a change of occupancy at the sale. Like I bought a house 2 years ago, I bought it and the people moved out. This is the same thing.
Isn't that what the legislature directs that we do?
Yes.
That we hypothetically, like there's some talk in the briefs that you shouldn't use hypotheticals. The statute says we should use a hypothetical. As of January 1st, we should pretend hypothetically that the real property, whether it's my house or the local CVS, we'll say, so we don't get into this case, is for sale that day. And then we look to see what an arm's length transaction between a willing buyer and a willing seller would be to determine fair market value. And it seems like that's exactly what the statute wants us to do. Now, getting into dark and how appraisers get there is a different question, but it seems
it's it's designed to make fee simple look ominous, and that's really what it is. But I would also say that if you look at let me put this here, the KSA 79503 defines market value and directs that we value the exact physical and legal characteristics of the property. So Wal-Mart owns and occupies all but one of these. They lease one. The county imposes the value of a lease on top of its ownership in fee simple, and then assigns value to it. And all you have to do, Judge Liebman, look at the chart on page 26 in my brief. The fee simple sales are all tightly connected down at the bottom to show that that's the only way you can achieve a uniform and equal valuation. But look at the blue sales that are all over the place. Those are sales that are purchased, and what they're buying is an income stream and a reversionary interest in the real estate. That is not fee simple. So all of those sales are bought exclusively on how many years are left on the remaining term of the lease and what is the quality of the tenant. And let me just explain why this is an issue. Johnson County testified, or one of the witnesses testified, the way they valued the property is on the assumption that a Walmart-like tenant is occupying the property under a lease with at least 30 years left on the term. I don't have a lease. I don't have 30 years left on the term. And more importantly, Judge Lieben, when Walmart goes out and has a sale of its property, it will not sell in this net lease market that the county talks about because there's no lease on it to sell. There is no income stream on this property. So to take a property, well, I say, here's the best example. They'd be like going to the apartment market and saying, I think I can learn something about what the value of my house is. They're not the same thing. So to suggest that somebody who buys, an investor who buys an income stream tells you something about what the value of the property would rent for in fee simple is just, you can't get there. They're just apples and oranges. And to the extent that I want to one plug for Preve, that was also my case. And it was written by Judge Green, who during his lifetime was, I think, the preeminent tax attorney in the state. And I think he understood exactly what he was saying. And he didn't foreclose the use of build-to-suit sales. He just said, if you have them, recognize what they are, disentangle the rights, and find out the value of the fee simple. Let's see. And one of the things Mr. Carpenter said, they cited to Architera. Could I just go back to Architera for 1 second? I argued that the county didn't carry their burden of proof in this case. The appellant was the appellant in Architera. I represented Architera in that case. I made the exact same argument there that I made here. And the Architera panel found that because BOTA ruled that none of the county's appraisals were prepared and developed and reported in compliance with law, that they have effectively failed to carry their burden of proof and made that ruling. So the argument there is the same as it is here, and I would ask the court to make the similar argument. I would also, let's pick one thing here, just a couple of questions. Our argument is, I think, Judge Bruns, where you are, the Cessna Credit Union case says, if you don't, once the court rules and interprets the statute, if you don't like the way we interpret it, don't come back to us and ask again and again and again. Go to the legislature and see if you can get it amended there. No, PREB has not been amended, the statute that it relied on. I will say this, though, once it defined fee simple and said it is fee simple unencumbered, that was in 2012, the legislature did amend the statute in 2016, requiring BOTA find the values in fee simple. And I think an appropriate statutory construction of that is they were aware of PREB and they accepted the definition. I would also note that my brief cited to Cregan, which is a Kansas Supreme Court case, and while not a property tax case, adopted the value of fee simple as it was stated in PREB. So a couple of points that the county raised that I just want to go through. That, there was a lot of stuff at the beginning of the brief, but none of that was tied to the record. None of it explained how it would diminish any order of the ruling of the board. But they did make three arguments. One was that the opinion wasn't supported by competent evidence and that assumed evidence not in the record. They complained of only one finding in that argument. One. And that argument was briefed on page 35. The finding that they disagreed with was BOTA stated that mayor's appraisal decisions and adjustments, quote, tease out the business/intangible element of the going concern and thereby arrive at the fair market value of the underlying real estate. The only challenge by appellant to that one challenged finding is the allegation that mayor only mentioned business value once in his appraisal. But it's important to where he mentioned it. It was on page 7 under property rights appraised. And he said, mayor literally says the entire appraisal is based on an attempt to value the fee simple exclusive of any contract rights or business value. And Mr. Lieben, that goes back to this question about build to suit. Those are contract rights and you need to remove them in order to get to the fee simple. So that's that argument. And then he also lists 10 items that he asserts were uncontested, but a cursory review of the expert reports of Lenhoff, Jones, Coors, Harrington, and Anderson proved this to be incorrect. But even
Counsel,
if it was true.
Counsel, I want to take you back to the bigger
Yes.
issue again for just a moment on PREB. If we were to say in this case that we think PREB is not, should not have so limited the ability of the Court of Tax Appeals to consider expert testimony about market rate for rent in owner-occupied buildings. If we said that it's PREB's legal analysis should not stand today in this case. We can't overrule PREB. We're just another panel of the Court of Appeals. We can publish a decision, but it is binding in this case. If we did that in this case, wouldn't the proper thing to do then be to send it back to the Court of Tax Appeals to consider what the proper ruling is without the overlay of PREB?
Okay, the answer to that is no. That would not be my greatest and fondest wish to go back to the board.
I know it's not your ask, but if we
But-
found
But
that
let me-
PREB's legal standard is no longer valid for this case, and the Court of Tax Appeals clearly thought they were bound by it in this case, wouldn't the right response be to send it back to them to refigure it out?
So the board did not say that you can't consider rent. In fact, Mayer developed all three approaches to value. The rent is only an issue in the income approach to value.
Well,
Mayer performed an
at
income approach.
at page 9 of their opinion, they said, in no uncertain terms, PREB instructs that an income approach based on build-to-suit rental rates was improper without a disentanglement by adjustments.
Right. Exactly. And they did not do that. And that's what the
understand,
board said. Board cited to Shaner's testimony where he said, I'm not going to do it.
I
And-
understand. If we were to say, we no longer say that that's a requirement, the Court of Tax Appeals ought to figure out based on appraisal testimony, what's the correct way to appraise something and what's the proper value of it. They
But-
clearly thought they were limited by PREB not to consider Mr. Shaner's testimony on that point, since he didn't disentangle by adjustments.
Right. But it's important to understand, Judge Lieben, it's not that they just didn't. They said they weren't. Corpac said there's no need to disentangle. Shaner said there's no reason to disentangle. The county says they don't see any reason to disentangle. They believe those build-to-suit rents are market rent. The evidence in the record is that they were not. When you go out into the marketplace, as Mr. Mayor did, and you find second-generation sales where the build-to-suit element is out of it, then you can determine what a property will rent for.
But do you
And
not say Mr. Shaner's testimony, for example, that's evidence in the record, right?
it is, but he says, I see no reason to disentangle. So if we
And
go back,
that's
what is
also
he gonna
evidence in the
do?
record.
yes,
But the Court of Tax Appeals said, we can't consider that evidence because PREB told us not to.
well, they did several things. They said not only did it not, but they agreed in, I think that's page 9. They said, where's the part where they said it is yes, because they found that PREB applies and they didn't disentangle, but they weren't going to use build-to-suits because they concur that they do not, the rents arrived at are not derived from the market.
What
And
page
that's
are you
the
on?
standard. I'm going to find it exactly here, just a second. Let's see. I swear I was in this part.
Because on page 10, they find that the appraisals compiled by taxpayer better adhered to the PREB mandate regarding build-to-suit rental rates than the county appraisals. So it seemed to me that the PREB decision was the key to the Court of Tax Appeals decision.
Yeah, I'm sorry, Judge Liebman, I'm just struggling here finding this one, but part of the, and maybe it'll hit me here in a second. Part of it was the board agrees that these rents that are derived from build-to-suit transactions are not representative of market. They're not derived from the market. Like, it's just like I said, it's like going out to the apartment market and saying, oh, I look at all these things, you know, they rent for this and sell for that. And then say, here's a 5-bedroom home. Let's say it's a 5-bedroom apartment and get an answer. It's not the same. So, and the reason why you have to stay within the market that the property is going to transfer in, which is the fee simple interest market, which is the real estate market, not an investor market. The reason you stay there is that's the only way you get to uniform and equal. If you start valuing properties based off of whether it has a 30-year lease to a credit tenant, and you look at that sale, well, and let me give you an example of why it's a problem. Let's take a building and let's say it's owner occupied, and somebody comes, they put a for sale sign on it, and it sells. We know what it sold for, just the land in the building. Okay, so that's one value. But take that exact same building on the exact same day. And say it's rented to Walmart with 30 years left on the lease. Well, they don't care what the condition of the building is or where it's located. They're only buying 30 years of income from Walmart, period. And they get a reversionary interest in the real estate at the end. But that exact same building will sell for a different number if there's 2 years left on the lease. So this is why you don't look at the actual build-to-suit leases, because they don't represent market value. And more importantly, they were done, let's say 20 years ago when the property was developed. And now we're, you know, look at Mr. Corpax's sales and rents. They're so old. They were all decided and determined and negotiated years before the valuation date, which is why the better method is to find what a property is renting for now, where there's not an existing lease, it's not a renewal, it's not already negotiated 20 years ago. It's put the sign out front, see who shows up and what will they rent it for. That's how you get to uniform and equal. If you start valuing properties based off of this other method, you're going to be in that blue area all over everywhere. And people will be punished if they have a quality tenant. And people like Walmart will be punished because we don't have a lease at all. What they have overlaid on top of our value of the real property is this value intangible contract right, and it put a value on it. And why do we know that? Because the year that they adopted the first Shaner report, and Judge Bruns, there are two Shaner reports, one covered 16, one covered 17, both of which were reviewed by two separate MAIs on my side, and both found them to be non-use PAP compliant.
In our record?
Yes.
Okay.
Yes. So Sarah Kors, who's an MAI out of Indiana, and David Lenhoff did the reviews of the Shaner appraisal report. Todd Jones reviewed Corpax, and he can explain, I mean, he found it not to be USPAP compliant. And every appraisal had a review in the record. Now I forgot what I was going to say, whatever it was. I know. Why do we know that it includes intangible values attributable to contract rights? Because the year that they decided to use the first time the build-to-suit rates, and they were all build-to-suit rates in the Shaner report, there were no market rents, all build-to-suit. The year they did that, the values doubled. Now, did the properties just become more worthwhile? No. And then I think Judge Brent, you may have been on the Target case in Wichita. In that case, the Target sold in fee simple for $4 million. Actively bid on by two national retailers, sold for $100,000 over asking price. Good sale. Target moved out, At Home moved in. About 6 months later, At Home puts on, and this is in our record too, puts on a lease, does a sale lease back, and puts a lease in place and sells it and gets an extra $4 million. Was that right? No, $5 million. So the value of that lease on top of the fee simple was $5 million. Now that doesn't make any sense. And there, Mr. Mayor has a series of these. Look at there were Kohl's stores, that one Kohl's store sold in fee simple. Later it had a lease in it and it sold for a considerable amount more, because land and building is worth one thing. Land and building and contract rights or intangible values worth another. And really, I think that's what Richard Green was trying to get at. He was trying to say, these are not market transactions. They are just, and as a matter of fact, Judge Liebman, they're never exposed to the market. When you do a build to suit, that if you and I are working on this, we're the only two that are talking about it. It's not exposed, that nobody else is bidding on it. Nobody else is telling us what the rents, they would rent it for a different number. It is just you and I. In order to have a market transaction, one has to have the rent or the sale exposed to the market. So Judge Grant is absolutely correct. The only way you can get to this is if you can disentangle it and figure out what the real estate sold for versus all this other stuff. And I don't feel like Boda was constrained by that. I think that clearly they understand they have to apply it. I would say after the Preeb decision was issued, they not only changed the statute that says you have to have it value the property in fee simple. They also included a provision in 742433 that told the board they had to follow published appellate decisions. So which is what I think the argument of the county is somewhat convoluted. I mean, it's a curious argument. They argue that Boda improperly interpreted Preeb, but then spent their entire case asking the county and the county asking the board and now you to overturn it. There really isn't this, there's a controversy in Johnson County, yes. But I don't,
You did mention several other states.
Well, Ohio is over. Ohio had a couple of cases and then they passed the statute says fee simple and
and that was part of my questioning. That was resolved by the legislature, correct?
Yes.
Which is, goes to the public policy part of this. I mean,
exactly.
I'm not sure how much the courts, especially giving inconsistent guidance between two panels, is helpful when you've got a legislature that's entrusted with public policy.
Right. And actually, if you look at the briefs that were filed in Arcatera, they're just almost the same as the brief filed here. There really isn't any greater in-depth discussion. There were different witnesses in the Wal-Mart case than in Arcatera, but the arguments advanced in the positioning of the parties is exactly the same. And yeah, it is, Judge Lieberman, it is maybe controversial here because the county has taken an aggressive position that they want to attach the intangible value of contract rights on top of property rights. But, Ohio is over. Wisconsin is not changed. I don't know anybody else. Michigan is clearly a fee simple unencumbered. And in fact, it was the attempts by the taxing jurisdiction in Menards with their expert witnesses to try and apply value to contract rights were so far wide of the mark, according to the Michigan court in Menard, that in a footnote, it suggested the county might want to ask for their fees back that they paid these appraisers because it's not the fee simple. And I will tell you, there's no, in terms of the definition of fee simple, I think Judge Brudge, you were the one that asked about this. The Johnson County took this case, that issue, and it is Johnson County, took that issue to the IAAO. They wrote a paper. They tried to get the Appraisal Institute to accept some new definition of fee simple. After a huge seminar with everybody involved, they refused. They've tried in Michigan, they've lost. They've tried here, they've lost. I don't see how under our Constitution, if you are mandated to do find the fair market value of the fee simple interest in real property, how you can recognize that you understand what those things are when it comes to housing, but you have a problem figuring out how it doesn't apply or how it should be treated differently in the commercial world. It just doesn't. Anyway, I would just suggest that that maybe this is not the case to go to the Supreme Court, because I don't know how a party purports to carry their burden of proof when they knowingly and willfully fail to follow the law and then expect you to overturn it and help them out of this. I think that Judge Bruns is correct and the Cessna Credit Union case is correct. If they want to change the law after it has been established, then their out is with the legislature. And if the legislature changes it to say we're going to amend the Constitution and treat commercial property differently than other classes of property, then that's the decision. And one other thing, the county also cites to Colorado Interstate Gas because they had some issue about does intangible value increase the value of the real property. I would just caution you that that's a public utility case, and our public utility statutes provide for the valuation of the real and personal, tangible and intangible value of a public utility. That is not standard for commercial property. It has been repeatedly held that the value is the interest we value is the fee simple. We don't tax intangibles or value leaseholds, which is a leasehold is at the build to suit issue. So I'm asking this court to sustain the order and make a specific finding, as the Architectura panel did, that the county failed to carry their burden of proof. And then maybe this issue can go to where it needs to be, is on the other side of 10th Street. Thank you.
Very much, Ms. Carroll. Appreciate it. Mr. Carpenter, you get the last word. You get 3 minutes.
All right, I will try and be succinct, obviously. Back to the fee simple issue, the county would cite to the Prieb case at page 130, Kansas tax statutes do not use the term fee simple. However, it is clear that the legislative intent underlying the statutory scheme of ad valorem taxation in our state has always been to appraise the property as if in fee simple, requiring property appraisal to use market rents instead of contract rents if the rates are not equal. Shaner and Corpax did not do any disentanglement of the rights because they determined that the contract rents were at market rent, and that can happen. Again, the county would respectfully request, as this tribunal or as this panel is able to do in the law, to re-examine Prieb based on the shifting foundation of the cases that underlie it.
Well, you understand, we can re-examine Prieb all we want to, but all you'll have at that point is conflicting opinions between, if we published, between 2 panels of the court. Now, maybe that will get the eyes of the Kansas Supreme Court on this issue, but you do understand we can't overturn Prieb.
You would be making a determination of where the case law sits today, with all due respect, Your Honor. So that would be a better snapshot in time than Prieb, as Judge Lieben pointed to almost a decade ago.
No, but I just want to make sure you understand, and the county understands, and anybody watching this understands, we cannot overturn another panel's decision.
Yes, but you certainly can rule differently, as you know.
Right. I understand that, but I thought you asked us to overturn it. So,
And the second thing is, all appraisal methodologies and treatises say value the market rent using market rents at stabilized occupancy. That is what the county has done here. You also have to value the property at its highest and best use. All experts that testified agreed that the highest and best use of this property is a single tenant retail. The mayor appraisal contains all sorts of inline smaller tenant properties that are not of the same highest and best use and that are not comparable. They're not good comps.
that sounds like a fact question to determine whether they're good comps or not. We don't know.
It's also a legal question because it's based on appraisal methodology, and appraisers are required to appraise in a manner consistent with USPAP. And
Right, but here you've got licensed appraisers on both sides.
right.
Let's go to another issue, because I don't want you to leave before this. I mean, to me, this is fairly significant, but it may not be, and I want to hear your comment. Ms. Terrell said that the Cregan case, the Kansas Supreme Court, although it was certainly a different issue presented, but it specifically adopted the definition of fee simple, or well, I won't say adopted, it specifically cited to Prieb for the definition of fee simple. Doesn't that send us some type of message that Supreme Court didn't balk at that definition?
And as I cited to Judge Bruns on page 130 of the Prieb decision, that says what fee simple is. It says that it's market rent instead of contract rent if the rents are not equal. So here you have in New York, the cases that underlie Prieb have determined that market rent is contract rent in certain cases. So that
I understand that. What I'm saying is, when the Kansas Supreme Court looks to Prieb's definition of fee simple, who are we to say it's wrong?
and with all due respect, Your Honor, this is a different case, a different scenario, different situation.
Different page numbers. Okay, so you would distinguish that case.
I would distinguish that case.
Okay.
Mr. Carpenter,
And
so I'll let you wrap up.
Okay, and thank you, Judge The last thing I want to say, and I was ready to wrap up, is Council for Taxpayer keeps asserting that the county did not meet its burden. Nowhere in that Board of Tax Appeals decision does it say the county did not meet its burden. In fact, that decision frequently refers to, it appears the county is preserving its record for appeal. They knew it was going to be appealed. They did not rule on that, and they ruled how they thought they had to, but the county is respectfully urging this court to re-examine PREB in the light of the shifting foundation that underlies it. And thank you for your time today, judges.
Thank you very much, counsel. We appreciate your excellent arguments today. We've kept you here a long time this morning. So
Thank
we
you.
appreciate your time.
Thank you
very
both.
much. We, of course, will take this case under advisement. I suspect we'll have a healthy, robust discussion about it, and we'll issue a written opinion as soon as we can. Thank you all.
Thank you.
Thank you.